You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 67, Patent Term Length and How to Get Your Patent to Last Longer. My name is Dr. Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondspatentlaw.com. That's D-I-A-M-E-N-T, patentlaw.com. Or if it's too hard to remember, you can get to it through patentingforinventors.com. That's patentingforinventors.com. Or call me at 424-281-0162. And while most attorneys can only practice in states where they're members of that state's bar, patent attorneys are actually allowed to practice patent law in any state. So feel free to contact me regardless of where you live. So I called this episode Patent Term Length and How to Get Your Patent to Last Longer. But it's probably not exactly the right terminology. It's not like you can do certain tricks to make your patent last longer. You used to be able to do that because patents used to last 17 years from when the patent issued. So you could postpone your patent issuing and keep it in a pending state. And you could prolong the date and when your patent expires because you could start doing all these little things where you tweak your application so it doesn't get allowed until you want it to get allowed. Now that changed in 1995. So now patents last 20 years from the date of filing. So it doesn't matter how long you try to postpone it, it's probably just going to last 20 years from the date that you filed it, with a few exceptions that I'm going to go over in this episode. First is that provisional patent applications don't count for this 20-year date. So if you filed a provisional patent application on January 1st, 2001, then on January 1st, 2002, you filed your non-provisional, your patent when it issues will last until January 1st, 2022, not 2021. So it's 20 years from your non-provisional date. So in effect, some people say that if you file a provisional application, it's like your patent term has a length of 21 years. I think it's a little bit misleading because it's not like you have an issued patent for 21 years. You still only have an issued patent from when it issues to when it expires. And if you take off the 2 to 3 years while it's pending, you're really still left with about 17 years of an actual issued patent. Now, like provisional patents, foreign applications don't count either. So if you filed your U.S. application based on a foreign patent application, the 20-year date is calculated from your first U.S. filing date. And when I say foreign application, I'm talking about an application from a specific country or specific region. If you filed a PCT application, which I've talked about before, the 20 years is from the PCT filing date. All that stuff is fairly simple to figure out, but here's where it can get tricky and where you can get a patent that might last longer than 20 years from the filing date. There's something called a patent term adjustment, PTA, and a patent term extension, PTE. Now you can look these up in 35 USC section 154 and section 156 if you want to know all the details. Patent term adjustment is more likely what you'll encounter. What can happen is that the patent office can be slow because there's a backlog, and it's not fair if the patent office is slow to ding you on how long your patent lasts. Let's take an extreme example. Let's say it took 19 years for your patent to issue because the patent office is really backlogged and didn't get your application until 19 years, and then it issued right away. So you only have 1 year of your patent before it expires, so that's 20 years from filing date. Now, that's not really fair, and the patent office knows this, so it wants to compensate for this difference. And of course, the patent office has to make this complicated. So there's Rule A delays, Rule B delays, Rule C delays, and then there are applicant delays, which can further complicate things. I'm trying to keep this simple. And if you want to know all the details for the patent term adjustment, these are in 35 USC 154. And here's some basic things. If the patent office takes more than 14 months to issue its first response to you, you'll get some time added. If the patent office takes more than 4 months to respond to your responses, you'll also get some time added. And if it takes more than 3 years to issue your patent, you'll also get some time added. Now, there are other kinds of delays of interference proceedings and secrecy orders and having to do with delays during appeals. So it does get a little bit complicated sometimes. These delays can't overlap, so you can't just add up all the number of delays and think that's the number of days that you'll get added. The question then is, what counts as an overlapping delay and what counts as a non-overlapping delay? And there have been some really interesting cases that go into this, and it can get pretty complicated. But basically, once you add up all the delays, subtract the number of overlapping delays, and then you have to subtract the number of delays caused by you for this application, then that's approximately like how many days are going to be added to the to your patent when it issues. Usually the delays that are caused by the applicant is that you took more than 3 months to file a response to an office action. That's the most likely one. There can be other types of delays, but that's the main one. There is a spreadsheet that you can use that the Patent Office has called a patent term calculator, where you can put in some dates and numbers and it will tell you when your patent expires, but it's only as good as the numbers that you put in. So if you don't really understand which rules the delay happened under and which overlapping days count and don't count, then you might get a wrong answer. The other way that patents get life added onto them is specifically if you're doing a drug-related or medical patent. This is called a patent term extension, and it's to compensate for the commercialization delays due to regulatory review. This mostly likely has to do with FDA approval. Since it takes a long time for drugs to get approved, the Patent Office doesn't want to effectively shorten the term of your patent because maybe it took 5 years for your drug to get approved. If you filed your application and you got a patent on it, but it took 5 years to get approved, it's not really fair that you didn't get to commercially use that for the full 20 years from the filing date. Now, typically, because of the time it takes to get a patent and counting extensions and everything, drugs usually have between 7 and 12 years of protection. Now, maybe you don't think that drugs should get patents, and that's fine if you think that, but that's really a whole other topic and has nothing to do with the current rules that allow for a patent term extension. There are all kinds of complicated rules about how much time is added, and if you want to know those details, those are in Section 35 USC 156. It's not just drugs that count, but methods of using or manufacturing the drugs. It can get really complicated to figure out this, and maybe you're thinking, who cares? If after 20 years after filing, you get an extra month or a year, why would you waste all this time and money for just a short period of time at the end of your patent? And you could be right in a lot of situations, but maybe you're wrong. Maybe the value of your patent won't be seen right away, but will be seen 20 years from now. Now, this is especially true for drug patents because generic drugs are just waiting to sell their generic version the day your patented drug expires. Let me just give you one example. When the cholesterol-lowering drug Lipitor was still under its patent, I read that it generated $24 million per day. Do you think that calculating and fighting for every single day of extension was worth it? Even if they paid attorneys thousands of dollars to fight for those extra days, you bet it's worth it to them. Now, most people aren't drug companies, and you'll just be looking at patent term adjustments, not patent term extensions. When your patent issues, it will say how many days of adjustment you have, and the Patent Office does its own calculation. But it's always wise to check and make sure they got it right. But honestly, for most people, by the end of 20 years, whether you have 1 or 2 months at the end that are added probably isn't going to make a big difference. But for drug companies, it does, and it's possible it might for you. Those are the basics on patent term extensions. If you want help with your patent application, responding to rejections, appeals, or anything else related to your invention, you can contact me through my website at patentingforinventors.com. That's patentingforinventors.com, or call Diamond Patent Law at 424-281-0162. I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com. or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.